Mr. Avella here.
Hey.
We're here on Mr. Wiggins. I'll let him.
Something else happened?
So, Judge,
No.
he has been consistently calling the complainant from the VPL from jail. I believe at last check on Friday, it was since March 26th, it was 130 times. Yeah. So,
Back in.
Well, he's in
He's
custody.
already-
He's in custody.
Oh, ag seg. Goes in ag seg.
Judge,
So privilege is revoked.
can we get Ramona to make a record for
Sure.
that? Okay.
so,
I'm up.
Judge,
Yeah.
Ramona wants to know for on the record.
Oh,
Yeah.
we are going on the record. If you want to talk, please go outside. Okay, so guys, for the record, please announce yourselves. Stay.
Action of the echo statement.
Anna Edie, EADY for Mr. Wiggins.
Nathaniel Meunier spelled Munier, also for the defense.
So hold on, before you get into anything, stay. You wanted to bring something to the court's attention.
Yes, Judge. So we had received a call that Mr. Wiggins was in violation of a protective order that was in this VPO, and that he was reaching out to the complainant witness in this case. We have checked the jail calls. Those jail calls show that since March 24th, which is, of course, after the October VPO, since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had at least 28 calls to that number.
So in one day, you're saying he made how many calls?
So yesterday, he attempted 28 calls to the complainant's phone.
I'm going to preface this conversation with, Miss Edie texted me about 10 minutes ago, so I came up on short notice on this. But my understanding is that there's no longer a protective order in effect because it's been long enough. The protective order.
There's an order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
Well, he is not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in custody. He has not broken
I
the
have
law.
ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of a court order that is not a bond condition, I believe the appropriate remedy would be contempt, which would be a separate criminal proceeding. At the same time, for Miss Edie talking to me today, it sounds like that the court was going to order ag seg in the jail, so the formal
The only
term-
way that we can revoke bone privileges on someone is ag seg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond. Thus, no crime has taken place. And third to that, Judge, if he's to move to AGSEG, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies, and
The
not being
only
able.
way, but the old is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to call, including our office as well as his felony attorneys. Letters through the jail are notoriously slow. A letter to my mother, who lives in the same city, takes 4 days. Add in the jail, you're taking over
And
a
I'm
week.
willing to put him on the docket one time a week so you guys can have contact.
Which the problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, him having conversations with us are saying, hey, what's going on with the felony? And any jail visits that take place in AGSEG are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not
Well,
prevent
Judge,
phone calls.
this would violate my client's 5th, 6th, 8th, and 14th, off the top of my head, constitutional rights. Right, self-incrimination, because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. He will no longer be able to have private visitation inside the court.
You can pull him out. You can have private visitation in the rooms
It's
there.
not about me, Judge. It's about felony court. It's a serious issue, but that's the
Why are you worried about felony court?
Because that's why he's in, Judge. Then
Well,
that's
it's also in because of ours. Our bonds are $60,000.
I understand, Judge, but the reason that this is taking as long as it is, and it's been taken as serious as it is because he's in custody on a felony. And this court making him to where he cannot participate fully with counsel is
There are other means for you guys to participate, but I've ordered you not to have contact with her. You've called her now over 300 times.
Sorry, Judge, I missed the last statement.
The only way that I can prevent him from making 300 phone calls is to put him in another wing.
I was going to talk with the DA, and obviously, if my client's making these calls, and that's an if, he's dialing a single number. The jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, as annoying as that is, it's very easy to block it on your cell phone. And I assume the victim could do the same. I have not heard anything from the state.
Tell the victim what to do, Nathan. Can you please block your number so we can't call you?
The least restrictive means, Judge. Strict scrutiny dealing with constitutional rights.
No other way to prevent him from making phone calls. I have acquiesced to you guys before, and I have admonished him before. Please don't. We put you in seg. Last time, you were there a month. You came here begging and pleading, I'm not going to do it, I'm not going to do it. And now we have 300 phone calls. So I don't know what else to do. But now, back in accent.
I'm going to sprinkle the word allegedly to the phone calls because it's the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I have them. I just have to get I have to do the form, so I get them up with the form. Yeah.
Okay, so let's set up a formal hearing because I don't want, you're right. I don't want to give you state the benefit of the doubt without him actually or Anna actually seeing it and seeing that the phone calls were actually made. So let's set up for a formal hearing. How soon can you get him the evidence?
It could be tomorrow, it'll be a few days.
And if we could keep him in normal population so that we could visit him, as does his felony counsel, and they can
Wiggins, I'm going to have you sign an affidavit from today promising me you're not going to reach out to the complaining witness in this case by any means. If you do, I can have a contempt hearing, and every single time it's punishable by up to 6 months in jail and a $500 fine per the advice of your lawyer. Because he thinks this is the correct avenue instead of ag-seg. Do you understand? No. Don't contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness.
I'm going to rephrase what he just said. That means calls going through third parties. So if you call mom and have mom call her, that's against the rules. If you call me,
that you're going to sign promising me you're not going to contact her or the complaining witness in any of my misdemeanor cases. Do you understand? But just get it as soon as you can. Get it to them. Have a hearing on Monday to see whether he's actually making phone calls that we ordered him not to.
This is you swearing that you will not make these calls.
And let it be clear that it truly have no least restrictive means than ability to make phone calls to the complaining witness. There really is no less restrictive means.
Judge, my understanding is that the jail can prevent Mr. Wiggins' SPIN number from calling.
In the last time, he used someone else's SPIN number to make the phone call.
And what's last?
So, well, we'll see this time. I don't know. Okay. All right.
Just for the record, Mr. Wiggins, I want you to make this aware that this is the court having you swear, which is legally binding, that you will not be making any calls. And if you violate this sworn oath, then that is punishable under the law. You understand?
Sure.
Okay. Thank you, Judge.
Thank you.
Thanks, Ed. See you Monday.
I wanted to approach on Mr. Wiggins.
Yeah. Sure.
So, and police come out to approach him, and I was in the process of getting the calls and everything, and I was informed that they were able to just block the number in the jail. So, and I wanted to just kind of...
But he uses other people's SPIN numbers to make the calls. So even if you...
Yes. And so...
Allegedly.
Right. So essentially the reason that I wanted to approach is, first of all, to let you know that I still haven't gotten the calls. I'm not sure what the ETA on that is.
You said it for Monday, right?
Yes.
Yeah. And I just wanted to let you know, I mean, from the state's perspective, when I talked to Jason, when I talked to, my superiors, when our act was to block the number. And I wanted to, let you know that has happened. Thankfully, in the last however many days, there's been no calls to that number at all from the jail. So I wanted to make you aware of that as well.
Can they block the whole phone number so that no one with any SPIN number can access it?
I can certainly ask.
I think that would be the optimal.
I think that would be optimal.
Because, what we have here, and the last time is the way that they were doing, what he was doing allegedly was he was using other people's SPIN numbers or SID numbers or whatever it is to be able to make the phone calls.
And, you know, when I was looking through the records, I didn't see any spin swapping because I ran obviously her number by itself. I didn't see any spin swapping recently. I understand that was an issue before. And you know, we hadn't blocked, I guess I would blocked her at the number since October or anything like that. So I didn't want to like know, just because I know that we have that hearing and everything. And I wanted to let you know that, you know, from our perspective, you know, our ask was kind of met. So I wanted to, you know, just kind of be a.
So you don't want to go through with the hearing? Is that what you're saying?
I think that our concern and what the state's ask was initially was met. So now I understand obviously for you.
Before you do that, make sure that they can't use someone else's spin to make a phone call. Because if you can, then I think we're still in the same boat. Because that was the problem before. You're going to block him now, but if you can still, you know, do it in another way. Yeah. And then just, I guess, let me know between now and then, you know.
And my understanding is that since Monday, no one from the jail has called that number, not just Mr. Wiggins. So there hasn't been any spin swapping since Monday.
Hey, but it was never supposed to be.
I understand, Judge. I just.
Yeah. And I more so just wanted to, you know, be candid that was what our ask was initially. Okay. So, you know,
Well, just let me know. I mean, ask that question. I think that's the most operative question at the time, and then we'll see what they say.
Okay. Thank you, Judge.
Okay.